If a party is seeking to offer witness evidence, the party must first lodge a written witness statement or a summary of the evidence to be given by the provision of a signed affidavit of the witness, and must secondly set out the reasons why the witness should be heard in person. If a specific technical or other question in relation to the action is to be reasoned, the court can of its own motion and after hearing the parties appoint a court expert. The parties can make suggestions regarding the identity of the court expert, their technical or other relevant backgrounds, and the questions to be put to them. The court expert must present an expert report in writing, attend the oral hearing if requested to do so by the court, and must answer questions from the court and the parties. The UPC also allows for experts to be appointed by each party. Private expert opinions commissioned by the parties can be equally introduced into the proceedings by way of expert evidence pursuant to Rule 181 Rules of Procedures and Article 57 of the UPC Agreement. Such experts, although instructed by and paid for by the parties, must follow a rule of impartiality in which their duty is to the courts and not to the parties instructing them. The questioning of witnesses and experts is under the control of the court and is limited to what is necessary in accordance with Article 53 of the UPCA. Experts may be directly questioned. The options mentioned are mostly contingent on the judge's permission. So can we predict whether or not judges will actually allow expert involvement? There are some factors steering away from expert involvement. Many UPC judges are from EU countries where paper evidence dominates, for instance France, Germany and the Netherlands, and their past experience may bias towards using paper evidence alone. UPC panels will always include a technically qualified judge if the proceedings involve patent validity, and such judges will be able to review and interpret scientific documents without expert assistance. We cannot, nevertheless, rule out expert evidence in some cases if the judges feel that it is appropriate. Indeed, some judges may be familiar with expert involvement from their experiences in national courts and therefore be more receptive. For instance, Sweden has a long-standing practice of oral evidence of experts in patent cases, and there are Swedish judges in both the Nordic-Baltic Regional Division and the Court of Appeal of the UPC. To summarize, we expect documentary evidence to dominate, with some expert evidence in writing and judges asking expert questions if they need more.